Hello, good afternoon everybody. I will first highlight two court filings. Last Monday, the tribunal's president, Judge Patrick Robinson, denied Momcilo Krajisnik's motion for early release. Krajisnik, one of the highest-ranking wartime members of the Bosnian Serb leadership, was transferred on the 7th of September 2009 to the United Kingdom to serve his 20-year sentence for crimes committed against non-Serb civilians during the conflict in Bosnia and Herzegovina. In denying his request, the President noted that while Krajisnik had displayed some, albeit very limited, evidence of rehabilitation, the very high gravity of the crimes and the fact that Krajisnik has only recently completed serving half of his sentence were two significant factors weighing against his request. The President recalled that the practice of the tribunal is to consider the eligibility of a convicted person for early release only after he has served two-thirds of his sentence. Krajisnik will have served two-thirds of his sentence in August 2013. In a submission filed on the 11th of July 2011, the Registrar of the Tribunal responded to claims made by Vojislav Šešelj during his initial appearance in his third contempt of court case last Wednesday that persons assisting him with his defense could not attend the hearing as the registry had refused to cover their travel costs. In his submission, the registrar pointed out that only accused who have been declared indigent or partially indigent are entitled to public funding for their defense. The registrar noted that the decision on the financing of Šešelj's defense, according to which the registry was to provide Šešelj's defense 50% of the resources usually allocated to a totally indigent accused, pertains to different proceedings, the main case against Šešelj. Moreover, that decision was not based on a finding of indigence, but rather on considerations related to the fairness and expeditiousness of Šešelj's main trial. As such, that case-specific decision does not provide a legal basis for disbursing public funds in the third contempt case against Šešelj in view of the fact that the accused has not been found indigent. Turning now to the courtroom schedule, at the status conference in the appeal case of Milan and Sredoje Lukic held last Friday, Judge Mehmet Güney ordered that the appeal hearing take place on Wednesday, the 14th of September and Thursday, the 15th of September 2011. Milan Lukic was sentenced to life and Sredoje Lukic to 30 years imprisonment in July 2009 for crimes against humanity and war crimes committed in the eastern Bosnian town of Visegrad. Hearings in the cases of Radovan Karadzic, Micho Stanisic and Stojan Župljanin, Jovica Stanisic and Franko Simatovic, as well as Zdravko Tolimir, continue this week and next as scheduled. In the Karadzic case, the trial chamber is currently hearing the testimony of expert witness Christian Nielsen, who is testifying about the Republika Srpska Ministry of Interior, its structure and internal functioning. In the trial of Jovica Stanisic and Franko Simatovic, the chamber is currently hearing the testimony of defense witness Mile Bosnic, who is a political scientist and former assembly member and minister in the government of the self-proclaimed Republic of Serbian Krajina. In the Tolimir case, expert witness Richard Butler, a former military analyst in the office of the prosecutor of the ICTY, is currently testifying. This afternoon, the testimony of defense witness Goran Machar, who has been testifying since Tuesday, the 5th of July, will resume in the Stanisic and Župljanin case. To conclude, I would like to bring to your attention the newly established International Criminal Justice Day, which will be celebrated every year on the 17th of July, the day of the adoption of the Rome Statute of the International Criminal Court. The Tribunal will join the ICC in celebrating that day this coming Sunday. The Tribunal will issue a press release to that effect towards the end of the week to provide journalists and members of the public with further details on the Tribunal's contribution to the commemoration. That's it from my side. Frederick?
Nothing from my side, thanks.
Okay. Are there any questions?
Yes, about Mladic's defense. What's the situation now? Did anything change?
As announced last week already, meetings were scheduled for this week with the two preferred counsel that Mr. Mladic had requested to see. And those, I can confirm that those meetings took place earlier this week, and further meetings are scheduled for the remainder of the week. From that point of view, progress is being made. The two lawyers provided the necessary documents to enable the registrar to consider their admission to the list of counsel and possible assignment. And that analysis is ongoing. However, as previously announced, Mr. Šalić, who is Mr. Mladic's Belgrade lawyer, doesn't meet at least one of the qualification requirements, that is fluency in English or French. And as such, he is not eligible for assignment as lead counsel. It is my understanding that Mr. Mladic insists on Mr. Šalić being assigned as lead counsel, which unfortunately is not allowed under the tribunal's rules. That's the current status.
Okay, and when do you expect the final decision to be made?
Most likely in the course of the week.
This week?
Yes, in the course of this week we'll have a final determination as to the eligibility of the two lawyers for assignment. Like I said a minute ago, unfortunately Mr. Mladic is not making that decision easy by insisting on a lawyer who doesn't meet the qualification requirements.
Did Mr. Mizyaev pass the English test, English language test? It was understanding that he was submitted yesterday to that test.
I believe he's taking the test today. Yes, and I assume the results of the test will be available probably within the next 2 days, which will also enable us to determine his admission to the Rule 45 list of qualified lawyers. Having said that, there is a very strong indication that Mr. Mizyaev, even if he were to meet all the qualification requirements, would not seek assignment as lead counsel. That's what he's told us.
And do we have any news regarding Mr. Mladic's health condition and his fitness to stand the trial?
Mr. Mladic's health situation hasn't changed in any significant way since his admission to the detention unit. As reported previously, his health is regularly monitored. Appropriate treatment has been prescribed, and there is nothing significant regarding his health status to be reported, apart from the fact that, of course, the health status as such is not a matter that I can discuss publicly. I don't know that anyone has ever requested an assessment of his fitness to stand trial. That matter is not before the trial chamber at present, so there is no indication that he is not fit to stand trial.
But, I mean, he was the one who mentioned that, I mean, not directly, but on both occasions, in the appearance, he was, claiming that he is very ill and he's too old and things like that he cannot hear. So, and who else would raise the question of his fitness for the trial? Not the standby, not this lawyer, which is just for the purpose of entering the plea. Maybe Mr. Šalić and Mr. Mizyaev did not raise that question. You were in contact with them.
No, and they didn't. To start, let me start with that last question. They didn't, and also they wouldn't have any standing to raise this question at this point because they haven't been admitted as counsel. The issue of an accused person's fitness to stand trial is one that requires a legal determination, a judicial determination, and it can only be decided upon by the trial chamber seized of the case. To date, no such motion has been filed before the trial chamber. Mr. Mladic has expressed some discomfort, let's say, or he has raised indeed some issues pertaining to his health. At the further initial appearance, Judge Ori, the presiding judge, made it very clear that the chamber would be very interested in discussing his health issue with the accused, but the accused has not provided his consent for his medical details to be revealed to the trial chamber. So it is a vicious circle. In other words, if indeed Mr. Mladic has issues to raise with the court, obviously he needs to allow the court to see that information before the court can rule on it. But as I said, the issue of fitness, one's fitness to stand trial, is a separate matter, which is a very formal judicial proceeding, essentially, and such proceeding hasn't been commenced before the tribunal.
What will be the next step once the tribunal determines that Mr. Šaljić doesn't speak the language and Mr. Mezjajev doesn't want to be a lead counsel? So where we are then? Should Mr. Mladic apply anew, or?
Thanks, that's a very good question actually, and one that we are asking ourselves as well, as you can imagine. I'd like to reiterate that there have been extensive consultations between Mr. Mladic and registry representatives over the past 6 weeks on the issue of Mr. Mladic's legal representation. And I have no doubt that Mr. Mladic understands the tribunal rules very well. He knows that if he requests legal aid, that is a tribunal assigned and tribunal paid counsel, he needs to comply with the rules of the tribunal regarding the qualifications of that lawyer. So, strictly speaking, he will have to select a counsel who meets all the requirements, all the qualification requirements. And maybe just as an aside, just to explain this very briefly so you understand why that is the case. This tribunal, as an international tribunal, doesn't function in the context of any one national legal system. And unlike national legal systems, there is no international bar association that licenses defense lawyers or attorneys to practice before this tribunal. The rules of the tribunal, the directive on the assignment of counsel, the code of conduct for defense counsel constitute the framework, the legal framework that governs the appointment of defense lawyers before this tribunal. And this is why there is a certain minimum of qualification requirements that the tribunal must insist on, and they come from the rules adopted by the judges in plenary, because those rules are a certain minimum guarantee for the rights of the accused. So I would like this to be very clear why these rules are in place, and it's not just a decision of the register whether or not to admit somebody. Those requirements are foreseen in the rules.
So he will have to apply again?
Yeah, he will have to provide another name, essentially. He'll have to provide another name of a lawyer who is fully qualified to be assigned.
And the registry will be ready to appoint Mr. Šaljić or Mezjajev as the legal advisors, or?
I don't see any specific reason why not. Under the rules, once appointed, lead counsel makes the request for the appointment of co-counsel and other members of the defense team, such as legal advisors, legal assistants, investigators, and so on. But I have all reasons to believe that in consultation with Mr. Mladic, in this particular case, whoever might be appointed as lead counsel would probably select Mr. Šaljić and Mr. Mezjajev and others as members of the defense team.
Do you think Mr. Mladic is deliberately throwing up hurdles to the case by this insistence on having an unqualified lawyer?
I hope not. It's really unfortunate that 6 weeks after our consultations with him started, he's insisting on a lawyer who doesn't meet all the qualifications for assignment. We haven't reached the point where I would be prepared to say that Mr. Mladic is deliberately obstructing the process. I don't think so at the moment. We continue to work with him, and as I mentioned, further meetings have been scheduled and will take place this week. I honestly believe and hope that we will be able to resolve this soon.
And you will let it know? You will issue a press release, or how shall we know that there is now an agreement about a specific lawyer?
When the registrar appoints counsel, be it under the legal aid system or otherwise, he issues a decision which is public, and that public decision will be disseminated to the media.
Okay, so we will know.
You will be notified, yes. Any other questions?
But when the appointments are refused for any reason, that there is no public release. You said that some kind of decision will be taken by the end of the week, so we will not know that. Yeah.
Well, let me clarify this, because last time I was a little bit misquoted indeed on this point. By the end of the week, we will most likely have a position on the eligibility of the two lawyers for assignment. As I said, the assignment of counsel is a consultative process, one that requires consent, essentially, between the accused, the consent of the accused, but also an agreement of the registrar. So we are still engaged in that process. A decision denying somebody's assignment is not always public, you're right, because usually when a lawyer is deemed unqualified for assignment, the accused is invited to select another counsel. And when they do, we just issue a public decision assigning that other counsel. Now, should this ever become such a big issue, you know, the decision can also be issued publicly. A decision is always issued, by the way. It's just that it's not necessarily always provided to the public. If there is such a big public interest in this particular decision, I would imagine the registrar may consider taking such a decision in a way that can be provided to the media.
And there are no deadlines for a new application by accused?
No, because the application is already there. The accused has applied for legal aid, and as part of that process, he requests the assignment of counsel. And until we reach the point where we will be able to assign counsel, that application will still be pending. Like I said, unfortunately, the process is not helped by Mr. Mladic's insistence on this specific lawyer to be appointed as lead counsel, given that he knows full well the lawyer doesn't fulfill all the requirements.
Is it, I'm sorry, just last clarification. Even if Mladic were paying for his own defence, Šalić would still not be allowed to practice here because he doesn't speak English?
Those are the rules, indeed. This is in conformity with the rules. I must say, however, that under the tribunal's rules, the qualification requirements for counsel privately retained by the accused are somewhat lower than those for tribunal-assigned counsel. And the reason is the one that I explained a few minutes ago. When the tribunal provides counsel, when the tribunal remunerates that counsel, we need to ensure a certain minimum level of qualifications. Under Rule 44 of the Rules of Procedure and Evidence, an exception could be made for a counsel who doesn't speak English or French if the accused privately selects such a lawyer, and there is a certain interest of justice test that needs to be performed at that point to see whether the registrar would be in a position to waive the language requirement. So that is one of the very few requirements that could actually be waived for a privately retained counsel. But up until now, we are not in that scenario at all because Mr. Mladic has made a request for legal aid.
This is one more thing, and apologies for asking, but people have asked me, why is Serbo-Croat, Serbian, Croatian not an official language of the court? Why do they need to speak English or French?
As you probably know, the proceedings of this tribunal take place in at least 3 languages simultaneously. So the reality is that the accused and often their counsel actually have full benefit of interpretation and translation into their respective languages. However, the official languages of the tribunal are English and French. These are the languages in which the proceedings take place. These are the languages that the Office of the Prosecutor is required to speak. These are the languages that the judges are required to speak, and this is also why the defense counsel are also required to speak one of those languages. You have to appreciate the enormity of these cases, and the fact that all the documents that are used are in English or French, and you can only imagine the delays that would be caused to the proceedings if all these documents were to be translated into languages other than English or French for the purpose of one of the parties.
And the last question, I hope, didn't Mr. Mladic amend his application in any way by adding some new name by now? No.
Do you know something that I don't? No, I don't think so.
I saw the Serbian lawyer together with Mezjajev and Šaljić as the lobby.
Yeah, that lawyer was already on the first list of 7.
Of 7.
Yeah.
Yeah. Okay. But
Yeah.
not on the yeah.
That's all I can say at this moment. He hasn't submitted any new names. Let's put it that way. He hasn't submitted any new
But
names.
still, all the cells are somehow in consideration, or all 7 of them.
Remember how it happened. Mr. Mladic had initially requested to see all 7 of them. Then at the further initial appearance, he stated that he only wanted to see those 2. And he hasn't explicitly withdrawn that list, but this is where we are at the moment. Any other questions? Well then, thank you very much. Have a nice day.